the general inquiry concerning environmental protection, we get into the specifics of the pollution control legal regime, which refers to the law, its enforcement, and the obligation of compliance and the manner of compliance. As was mentioned in the previous lecture, the evolution of the law in India concerning environment has not been a very logical one, that you start with the general, the environment, you start with the policy and then get into the law and then go to the specific aspects of pollution control like that. In fact, this has been the experience in the Western countries. United States, for example, they came up with an Environmental Policy Act, National Environment Policy Act, way back in 1969, and followed it up with a couple of legislations dealing with clean air and clean water, the laws in relation to that. We have a bit of the latter preceding the former, that we started with the pollution control regime and then moved into the broader theme of environmental protection. Be that as it may, in this inquiry, our discussion would be focused on the law concerning pollution control in India. The background is very simply this. The year was 1974. The Parliament was taking stock of the environmental regulations in India. It had to take stock for the simple reason that 2 years before that, in the year 1972, they had already the experience of participation in an international summit, the Stockholm Conference on Human Environment, in which, like India, all other countries went back to their respective parliaments to come up with specific legislations to deal with the crisis problem of environmental degradation and the threat of the entire snuffing out of life from Mother Earth. The need of the hour was not a very general law as we had adopted through the general administration of common law and criminal law, of nuisance, negligence, and liability, about which we reflected on earlier. These were pretty old tools which are fairly blunt. Along with pollution, they were dealing with so many other issues. There was nothing like a very focused attention to pollution control, and that was the need of the hour. Old tools, and facing this new challenge of an environmental crisis, and we had given an international commitment that we would come up with our own laws in this regard, and so the need was to come up with a far more sharp, far more effective, far more focused piece of legislation and a dedicated, specialized body of enforcement with all the skills and capabilities as is required to deal with wide variety of pollution issues. As a matter of fact, even in the 6th five-year plan document of Government of India, a small chapter referred to the environmental problems and what the Government of India intends doing. And this was later followed by a far more elaborate plan document in which quite a few legislative measures that were taken on behalf of the Government of India to deal with the problems of pollution, which was the immediate and an urgent need. And in 1974, we came up with the Water Prevention and Control of Pollution Act. In the slides that we have here, I have used the acronym WA to indicate this for saving space, and that will be followed uniformly all throughout this set of slides. And along with that, 7 years hence, we came up with another law called as Air Prevention and Control of Pollution Act, 1981, AIR Act for short, acronym AA in all the slides that we are going to have now. In between these two legislations, 7 years apart, we have another small legislation, a very small one, which actually wanted to help the institutional machinery to become a self-sustaining body, to collect some kind of a cess for the consumption of water that has been used by each and every industry, and that was the law called as the Water Cess Act of 1977. Together, this constitutes the pollution control legal regime in India. And for these legislations, although these were different legislations made at different points of time, the administration is the same. And since 1986, after the Environment Protection Act was passed, the source of authority of these two legislations and the institutions created under them is the broader Environment Protection Act. And over time, the Environment Protection Act, under a various set of rules and regulations, additional functions beyond whatever that has been prescribed in Water Act and Air Act, have been entrusted to the institutional mechanism created under this body of law. A very unique development. From a general law, we get into very specialized, focused attention with specialized entities who are not the run-of-the-mill governmental agencies, but specialists dealing with autonomous bodies, dealing with issues of pollution. And here we look to the sources of these laws. How did the Water Act come into existence? As was discussed in the session on the Constitution, water is a state subject, and only the states could make a law. But a number of states came together. They felt that having their own separate laws concerning water pollution, some of them would have stringent provisions and some of them have very lax provisions, with the result that the pollution in one area may affect the other areas. And since pollution, especially in the atmosphere and in the water bodies, do not really know the barriers of the state, district, taluk, or anything like that, it is very necessary that we have some kind of a uniform law all over India. And as has been provided in the Constitution, as many as 12 states approached the center to make a law, and subsequently all other states followed this. And now we have, in 1974, the Government of India coming up with a legislation entitled Water Prevention and Control of Pollution Act. The origin of Air Prevention and Control of Pollution Act of 1981 is quite different. It is also inspired from the Stockholm Summit, where India made the commitment that we will come up with pollution control laws. But we had only enacted a law concerning water pollution. We had not enacted a law on air pollution. And air does not come within any of the lists. And second, this resource, which is common to everyone, required a national attention and very much necessitated by the Government of India to invoke that particular provision of the Constitution, Article 253, which actually obligates the Government of India to fulfill its international obligation to come up with the necessary legal mechanisms to operationalize and internalize whatever that they had committed at the international level. And so the roots or the origins for the Air Prevention and Control of Pollution Act in the year 1981 is essentially Article 253 of the Constitution. Using that, the Government of India came up with a law applicable to every state in India. And now, with the enactment of the Environment Protection Act in 1986, as was mentioned earlier, the working of the Water Act and Air Act are aligned to it. Let's look into the objects and scope of each of these laws. The Water Act is essentially meant to do two things: prevent and control water pollution. That's the primary objective. The second primary objective is to maintain and restore wholesomeness of water. So the authority's function will not end with prevention and controlling of water pollution, but it's also a proactive function of maintaining water quality. And if the water quality has deteriorated, then to restore the wholesomeness of water. So twin functions. And one of the major features of this law is that it has an overriding effect over all other laws. The status is confined to this act alone and not for the rules, unlike the Environment Protection Act, where the status of overriding effect is there for the rules also over other laws. But here, the rules are subordinate legislations. Although they need the parliamentary approval, they are very much part of this statute, which overrides the other laws on issues on water pollution. It has quite an elaborate set of penal provisions to deal with almost every kind of violations. The scope and extent of application is not just confined to pollution, it extends to contamination, alteration of the properties of water, discharges into water, issues of nuisance, harmful to human health, to the plant varieties and animals, ultimately to the entire environment. This is applicable to entire India, and upon adoption by all the states, it becomes operative uniformly all over India. Now, adoption means what? A state may adopt this law, but having adopted this law, a state is supposed to do one more thing. And what is that? Section 19 makes it very clear that each state, after having adopted the central law as part of its law, it has the power to extend or restrict the application of this law to any part of that particular state. A very unique law. You adopt the law in its entirety, but in terms of application, you have to come up with a clear gazette notification to the effect that this law is applicable to the entire state, or is confined to a particular area, or it does not operate in a particular area. So the rules, regulations, notifications that are there under this law will be operative only where it has been designated to be operative, as has been stated by the state government through a notification. Let's look to the Air Act. What is the objective? It is to prevent, control, and abate air pollution. And this has an overriding effect over other laws, just like the Water Act. Just like the Water Act, the rules made under this also need have to go through the parliamentary scrutiny of approval. But like Water Act, the rules there, here also the rules do not have an overriding status and power over other laws. So only the statute, the act, has an overriding effect and not the rules. Similar to Water Act, the Air Act also has very elaborate penal provisions. In terms of the scope and extent of application, it follows the pattern of Water Act. It is applicable to the whole of India, and every state which has adopted that will have to come up with a clear gazette notification to the effect that they declare what is referred to as an air pollution control area. And it is in this area this law is made applicable. They may declare the entire state, as the air pollution control area, then for the entire state this law is applicable. Or if they say that this is only confined to a cantonment area, this is only confined to the industrial area, then it's applicable only in the industrial area. The standards prescribed there, the permissions that are required to be obtained from the authorities is confined only to that area and not beyond. But one thing that one should note here is, once the state government has declared a particular area as an air pollution control area, in the entire area uniformly, without any exemption, this entire act has to be applied. All the terms and conditions, the specifications there, the obligations of compliances are operable in the entire area. The government, after having notified like this, it cannot give it to the administration to use its discretion to apply the law in one particular area and exempt other areas. This was actually laid down in a very important case decided by the Karnataka High Court in the year 1998, the case of K. Muniswamy Gowda versus State of Karnataka. That you either apply the law to the entire air pollution control area or don't declare that area as air pollution control area, whereby you can use your discretion. But once the area is so declared, there is no discretion left with you to pick and choose which industry to whom the entire law is to be applied and which industry should not be applied. It should be uniformly brought into application. What is air pollution? As defined under the Act, it refers to the presence of solid, liquid, or any gaseous substance in atmosphere that in actual terms or has the potential or the tendency to be injurious to human beings or other living creatures. This is the definition of air pollution. So what you are looking into is something which is not the normal air that you breathe, but something has been added to that in these forms, in any of the state of nature, in the atmosphere, which affects human health, human well-being, or other living creatures. So that is what is referred to as air pollution. To this, in the year 1987, one more extended definition was given, that air pollution also includes noise pollution. So that is the object, the scope and extent of application of this law. Let me refer to a couple of cases to interpret and explain how exactly these laws would operate. There was this wonderful case decided by the Gujarat High Court in the year 1996. The case is Dahyabai Solanki versus NJ Industries. In this particular case, the State Pollution Control Board, the agency which has been entrusted with the task of enforcing this law, issued a notice to one particular industry. What is the alleged offense? That you are releasing untreated effluents in the form of, through the chimney of your industry into the atmosphere. You are releasing those which are blameworthy substances into the atmosphere, which actually results in air pollution, and so we will proceed against you for having violated the law. The question before the court of law was whether the industry is actually guilty of this. That is a normal thing that we understand. The industry did not challenge this at all. That it did not say that we are not releasing it. All that the industry argued, it's a very interesting argument. All that the industry argued is, under which law you are going to bind us? And this happened in Ahmedabad, the capital city of Gujarat then. The question the industry posed before the court of law was, under which law you are going to bring in an action. Does this particular authority have the jurisdiction to take action against us? Show us in the rule book. The Pollution Control Board argued, look, what we are submitting before you is a polluting activity they have not challenged. They have polluted the air, and we are the authority to control, abate, limit the effect of, and eliminate the adverse impact of air pollution, and for which we are authorized and empowered to act. The court asked them the question, we have this power, we don't question, and not even the industry would challenge. But they're only asking about your jurisdiction. Your jurisdiction comes only when this act is made applicable in this area. Shows the gazette notification, which declares Ahmedabad as an air pollution control area. In the previous slide, we have already seen, in order to apply the law, you need to be very clear that there is a gazette notification to that effect that that area is declared as an air pollution control area. And the fact of the matter was, the Pollution Control Board was unable to produce the required gazette notification, which actually did not exist. And so, unfortunately, on this technical count, the industry was let free. It was a polluting act, but the jurisdiction of the authority under this law was not established here. So look at that. You may come up with a specialized law, but unless you have taken care as to bring that into application as is required under this law is as good as a paper tiger. A little further elaboration, we move to the other extreme of India, the eastern part of India, the Mahabir coke industry versus the Pollution Control Board in the state of Assam. It's a decision in the Guwahati High Court. Here, the industry had applied for consent from the Pollution Control Board under the Water Act, and it was carrying on its business. But this industry should have got permission even under the Air Act, because it was not only going to be brought within the purview of the Water Act because of the release of effluents, the liquid form into the public place, and so it may even affect the water quality or anything like that in the public space. It was also, since it is an industry, a coke industry, it would release fumes into the atmosphere, and these fumes, whatever that is released into the atmosphere, needed to conform to the specifications under the Air Act. So it should have come under that law as well, but they had not made even an application to get that permission of the Pollution Control Board. An inspection was carried out by the Pollution Control Board, and they said, look, you have the permission for Water Act, but you don't have permission under Air Act. Why don't you apply? So 2 years later, they make an application. And the same year, that was the year 1993, the government of Assam announces the entire state through a gazette notification as an air pollution control area. Very interesting development. Now, when this order was passed by the government and this application by the industry was pending under the Air Act, on scrutiny of the application and on physical verification by the Pollution Control Board authorities, they come to a conclusion that the requirements of the Air Act are not satisfied of putting up air filters in the chimney to filter all those toxic substances, to release only that harmless gas into the atmosphere is not followed by the industry, and so we don't give you the permission. So you don't have the permission because you're releasing black smoke into the atmosphere, and so you have not taken preventive measures. We will not give the license to run this industry under the Air Act unless this preventive measure is taken by you. Not just that, since you have not complied with this requirement, we will say and give you an instruction to close the industry till you come up with corrective measures. The court was asked this question: is Air Act applicable here? Water Act is applicable, for which permissions are obtained, and so they're carrying on the business there. What about Air Act? And please remember that the Pollution Control Board has made two demands from the industry. Number one, you have been polluting the air and the atmosphere for the last 2 years, and so you have to pay a penalty for 2 years lapses for cleaning up. The polluter pays principle, number one. And number two, that since you do not have the permission to run this industry under the Air Act, and you have not taken any preventive measures before you made this application to us, and that was the condition we laid down. To give you the permission, you have to install the air filters. Since you are not done, we will ask you to close down the industry. Two actions. The question before the court was, were these two actions justified? It's a very debatable judgment, but still, on a technical count, the judgment given by the court is right. What is that? That the Pollution Control Board cannot have the jurisdiction on both the counts of imposing penalty for 2 years of polluting the atmosphere through black smoke. The question was, how do you decide it's a polluting activity of the atmosphere? It's a polluting activity under the Air Act. Was the Air Act operative there between 1991 to 1993? Look, by your own admission, you have stated that we as the government, through a gazette notification, we declared the entire state as air pollution control area in 1993 only. So till 1993, Air Act was not operating there. And so how you can come up with this condition even before the law has come into existence? And so the penal sanction that you have imposed is inapplicable. And the second one, as to asking this industry to close down till these conditions are satisfied. Come on. Where do you get this power? You get the power under this act, but the act is not in operation. And it comes into operation only after 1993, after we had made the application. So there must be some provision with regard to that of giving some concessions or whatever. And so how can you ask us to close down? So accepting this, the court came up with this decision that the action taken by the Pollution Control Board was wrong. The reason why these two case laws are given is to drive home the point that it is not just that a law is made and the state has accepted that this is a law that's applicable in my state, but it has to come up with some more preparation before it makes the law work to come into effect. It comes into effect from that day when all those preconditions are satisfied. Unfortunately, in both these instances, although the industry was a polluting industry, the court's hands were tied because the law has very specifically required that these conditions needed to be satisfied before the authorities can swing into action.